Well, hello again, everyone. My name is Dr. Jim Ludis. I am the Vice President for Public Research and Initiatives here at Salve Regina University. I'm also Executive Director of the Pulse Center, and it's my distinct pleasure to welcome everyone to this first lecture of the fall season. It's a virtual event. You may have figured that out by now, but we're thrilled to be able to continue this series despite the pandemic and do so in a way that lets us all continue these conversations in the safety of our own space, appropriately socially distanced, not having to wear any masks. So I'm thrilled that everybody was able to join us. We've got a great series of events signed up for this fall semester. In a couple of weeks, we're going to continue our look at the politics of 2020 with presidential historian Robert Dallek. We have another event in October on cybersecurity in the fall in the November elections. And after election, we've got an event with Evelyn Farkas and with David Schuster, who you may have seen both of them pretty prominently on cable news over the years, talking about what do the results of the election portend for the future. And then finally, we've got another event on the pandemic and the social justice issues associated with it, and an event that we're still putting the finishing touches on the future relationship between China and the United States. So we've got a dynamic fall lineup coming your way. We hope that you'll be back and you'll join us for this series as the semester progresses. Tonight, we've got a very special treat. Dr. Tony Arend is someone who, if you've spent any time at Georgetown, is known for his personality, for his performance in the classroom, and for his reputation as a scholar. I got to know him a little bit when I was a graduate student there. We've stayed in touch over the years. And when I reached out to him, he was gracious enough to say he'd be thrilled to join us. When I mentioned this to my great colleague Bill Lehman, who is the director of the Pell Honors Program, he thought that Tony would be a great fit for the lecture for the Constitution Day lecture, which is why we're here tonight. So this event is co-sponsored with the Pell Honors Program. And I want to thank Bill and that great program for all of their support as well. Tony, as I mentioned, is a legend at Georgetown. He is currently a professor of government and foreign service and chair of the Department of Government. He's served in a number of administrative capacities at the university, including a stint as director of the Master of Science and Foreign Service program from 2008 to 2017. He's published 7 books on a wide array of legal and international issues. And so it's appropriate tonight that he's going to give us his take on Constitution Day 2020 and a look in particular at the Constitution and U.S. foreign policy. Tony, thank you so much for being with us.
So, Jim, it's a great pleasure to be with you. I wish we were in the same room up in Rhode Island, but this is the next best thing. It's an honor to be here with my old friend, Jim Ludis, and particularly on Constitution Day. And I have to say, especially at the Pell Center. Claiborne Pell used to live around the corner from me here in Georgetown. And I never had a nice house on 35th Street. I never met him at that point in time, but I did meet Senator Pell in 1994 when I was testifying before the Senate Foreign Relations Committee. This is when he was chair. And I was testifying on the constitutional authority of the president to use military force pursuant to a United Nations Security Council resolution. And so I was honored to be there. Michael Beschloss was on the panel and Jane Stromseth. And so I was talking, and in the course of the discussion, Senator Pell mentioned how he was at the San Francisco conference in 1945 when the UN Charter was adopted. And of course, I'm sitting there at the witness stand thinking, and what do I have to say? He was present at the creation. So it was an honor. It was an honor to meet him under those circumstances, and it's therefore a special honor to be with all of you at the Pell Center. I am going to share some slides here, and Jim, you will let me know when this looks like it's supposed to look. Give it a second. Yeah. Give it a second here. I'm hitting the button, and here we go. Does it look good?
It looks great.
All right, excellent. Well, I'm going to talk about the Constitution and foreign affairs. And I'm going to start off, and this is a typical law professor thing to do. I'm going to start off with a hypothetical, but it's something that's been in the news. So that was a headline from the New York Times recently. Allies and former U.S. officials are concerned that if President Trump were reelected, he could seek for the United States to leave NATO. He could pull the United States out of the NATO alliance. Okay, let's play with that hypothetical a minute. Let's say Trump is reelected, and let's say on January 20th, the day of the inauguration, President Trump withdraws from NATO. Okay, Congress goes crazy. And let's actually say it's a bipartisan going crazy. So Nancy Pelosi and Mitch McConnell say, what are you doing here? This is the worst decision you could make. Well, can he do that? Can the president, under the U.S. Constitution, just withdraw from NATO without consulting Congress, without getting the approval of the Senate, without somehow engaging the legislative branch? Well, our first question on this hypothetical, what does the Constitution say, right? If we're asking whether the president has the constitutional authority, what does the Constitution say? Well, Article 2, Section 2, the president shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. Well, that says how the president makes treaties. It doesn't say how the president unmakes treaties. So how do we figure that out? How do we resolve this constitutional dilemma? Well, maybe we resolve it the same way we would a lot of other constitutional dilemmas, like what does the First Amendment mean? What does the Fourth Amendment mean? Maybe we go to the courts. Well, this has happened before. In 1979, President Jimmy Carter actually terminated the Taiwan Defense Treaty, didn't consult Congress, didn't consult the Senate. What happened? A number of senators were kind of ticked off. And one senator that was ticked off was Senator Barry Goldwater. So what did Barry Goldwater do? He sued President Carter in federal district court. He and a handful of other members of the Senate brought suit against President Carter. So, okay, so we're going to get a resolution here. Can the president unilaterally terminate a treaty? Can the president do this without getting congressional consent? Well, went to the federal district court. So Judge Oliver Gash there said that it's the decision of the court that the president's termination must receive the approval of 2/3 of the United States Senate. So the federal district court said, President Carter, you cannot do that without Senate consent. It's made with the Senate. It has to be unmade with the Senate. Well, President Carter wasn't going to just sit by idly and accept that district court decision. This was part of the process of recognizing the People's Republic of China. So, appealed it to the D.C. Circuit Court of Appeals. What do they say? They say that they found that he did not exceed his authority when he took action to withdraw from the Republic of China treaty. So, you now have the Court of Appeals saying, President Carter, you acted permissibly. But Goldwater's not happy with this, so they're going to petition the Supreme Court for a writ of certiorari. Take it to the Supreme Court, have a final resolution, and the Supreme Court could tell us whether the president has the authority unilaterally to terminate a treaty. They didn't. Supreme Court said the judgment of the Court of Appeals is vacated. So whatever that Court of Appeals said, forget about it. The case is remanded to the district court with directions to dismiss the complaint. Why? The Supreme Court said this issue is not justiciable. It's not the kind of issue that courts should deal with. We're not going to resolve it. Get out of court. Now, at the end of the day, that meant that President Carter was able to get away with it because the courts refused to adjudicate the merits of the case as to whether the president could unilaterally terminate a treaty. Now, I start with this hypothetical because it reflects the essential thesis of my talk, and that is that the Constitution says little about foreign affairs. It doesn't really tell us that much about foreign affairs. And some of the most critical provisions of the Constitution are vague and unlikely to be resolved by courts. So, with that thesis, I'll look at four things. First of all, a brief review of what the Constitution says about foreign affairs. Second, competing schools of thought, how people interpret what this actually means, what those provisions actually mean for foreign affairs power. Third, to talk about some trends in practice. And then finally, to give you the answer. Of course, that's the whole goal, is to give you the answer. So, what are the constitutional provisions on foreign affairs? There aren't really that many. We start off in Article 1 with the congressional powers. And the Constitution actually delineates more congressional powers than it does presidential powers. Now, some of this stuff is pretty familiar. Congress has the power to regulate commerce with foreign nations. That's a very, very important power, and it connects obviously to international trade, international commerce. That's Congress's authority to regulate commerce with foreign nations. Congress also has the authority to define and punish piracies and felonies committed on the high seas and offenses against the law of nations. That's not insignificant. Controversial. It means Congress has the authority to criminalize certain behavior, to put it as part of the criminal code, both piracy, felonies that are committed on the high seas, and then violations of the law of nations, which are violations of international law. So Congress can criminalize violations of international law. But the last one on that page, that's pretty significant. Congress has the power to declare war. Pause there. Grant letters of marque and reprisal. Now, that's not something that's been used for well over 100 years. That's creating privateers and empowering private captains of ships to do various things on behalf of the government, but the power's there. Make rules concerning capture on land and water. That's not insignificant, because those are basically Congress adopting and creating laws of armed conflict. But the big one there is Congress has the power to declare war. Now, Congress also has related war powers to raise and support armies, to provide and maintain a navy, to make rules for the government and regulation of the land and naval forces. Now, those get manifested in the Uniform Code of Military Justice, not insignificant. Provide for the calling forth of the militia. So the militia these days would be the National Guard. These were the state militias back in the day. Congress could provide for them to be called forth to service. As you can see, to execute the laws of the Union, suppress insurrections, repel invasions. Congress also has the power for organizing, arming, and disciplining the militia and governing them when they are in federal service. So it's Congress that's supposed to give us the Army and the Navy. By the way, it's interesting to note there, armies is plural, navies is singular. When I talk to my students about this, I said, did James Madison have a problem? He make a mistake in parallelism? Not really, because the framers thought that there would be a standing navy, provide and maintain a navy. But they conceived of armies as being raised for particular conflicts. There was not to be, in their view, a standing army, which is why you then see the next line about the appropriations being for no longer than 2 years. Now, part of it was they didn't think they needed to have a standing army, and part of it was, if you're going to abuse a military force against your domestic population, it might be the Army more than the Navy. So that may have been a concern as well. So those are the congressional powers. Again, not particularly extensive, but not insignificant. What about the presidential powers? What does the Constitution say about the president's authority in foreign affairs? Well, there's the big one. The president is the commander-in-chief of the Army and the Navy and the militia when called into federal service. The president is the commander-in-chief. Second provision there is the one we talked about in our hypothetical. The president makes treaties with the advice and consent of the Senate. The president appoints ambassadors and other public ministers and other officers that are listed there. The president also, you appoint ambassadors, you receive ambassadors and public ministers. And there's a nice ceremony that when someone comes and presents their credentials. The president shall take care of the laws be faithfully executed. That doesn't just apply to foreign affairs, but it's an important function of the president. And the president is to commission all the officers of the United States. And that is where we get the concept of commissioned officers in the U.S. military. Okay. Now, if you look at this, go back, the congressional powers are actually more specifically delineated. There's more in the Constitution than presidential powers in foreign affairs. And that leads some people to say, well, maybe there are more congressional powers in foreign affairs, and other people to say, no, you didn't have to say too much about the president because there was assumed that there was presidential authority. Well, what's the answer here? There tend to be sort of two schools of thought about the war powers, the other powers, the presidential powers, the congressional powers in foreign affairs. And on the one hand, and obviously that's Lin-Manuel Miranda, but representing Alexander Hamilton, there are the presidentialists. And on the other hand, it's James Madison representing the congressionalists. Among the framers, the presidentialists felt that in the area of foreign policy, the president had broad, exclusive, in some cases plenary authority. Matter of fact, the Supreme Court case, Curtis Wright, where the court said that the president is the sole organ of foreign policy. So the presidentialists assert the supremacy of the president over Congress in the conduct of foreign policy. Now, the congressionalists don't assert the primacy of Congress over the president, but rather they say that Congress and the president are partners in the conduct of foreign policy. The congressionalists recognize that there are certain exclusive powers of the president. I mean, we just saw a couple. The president receives foreign ambassadors. The president appoints U.S. ambassadors. There are certain areas which the congressionalists recognize as exclusively within the president's realm. But in so many areas, the congressionalists would say the powers are shared. The president and Congress are partners. Now, those are two framers. Who are some people we might put into this school today? And the one kind of easy one is just about everybody that's been, matter of fact, everybody that's been president is a presidentialist. They have always asserted broad presidential authority, and that's why I put 5 presidents in that picture. A lot of congressionalists have been in Congress. There are some presidentialists in Congress. Someone like an Orrin Hatch was kind of a presidentialist, notwithstanding that he was in Congress. But I put some prominent people there. So Tim Kaine, senator from Virginia, I put him there because he's been very concerned and active about war powers. The former Congressperson Elizabeth Holtzman, in large part because she was very active in the Watergate period, but she was also someone who challenged the war powers during the Nixon and subsequent administration, the Ford administration. She actually brought suit against James Schlesinger when he was Secretary of Defense. So Elizabeth Holtzman. Now, there's Joe Biden. Joe Biden is running for president, but has a strong record of asserting strong congressional authority in the conduct of foreign policy. I mentioned testifying before the Senate Foreign Relations Committee in 1994. The person that jumped all over me was not Senator Pell. It was Senator Biden. I had made the claim that I thought the president could use force in short, quick military operations. Biden went all over me and said, well, Professor Arend, what do you mean? And he was really in a tirade because he supported strong congressional authority in the conduct of warfare. Now, it's interesting, and there's a long record. You could look it up. It'll be interesting. In the event that he is elected, will those congressionalist views suddenly be changed and he'll be more like the guys there on the left? Or will he keep some level of this idea that Congress is a partner in ways that maybe some of those other presidents didn't? Now, let me just show as an illustration how these two schools of thought interpret these two sections of the Constitution. So you have Article 1, Congress shall have the power to declare war. Okay. Article 2, the president shall be the commander in chief. Okay. If you're a congressionalist, you tend to look at that and say, what that really means is pretty much any time you want to use military troops abroad, you need congressional authority. Now, the Congressionalists will say, yeah, if we were suddenly attacked or something like that, you don't necessarily need to get congressional authority then. A Pearl Harbor, even though Roosevelt did get congressional authority after Pearl Harbor, but an attack or a 9/11, they might say you don't need it when there's been an attack. But pretty much every other use of force, you're moving into Panama, you're moving into Haiti, you're doing airstrikes in Libya, you're taking out Soleimani. Pretty much in all those things, Congressionalists are going to say the provision that says declare war really means the Congress should authorize the use of military force in just about every case. Now, the presidentialists focus on the commander-in-chief role, and they say, no. The declare war provision means, this is a presidentialist, that if you're going to engage in major sustained hostilities, World War II, Vietnam, the Gulf War, the Iraq War, yes, you need congressional authorization there. But they would say, the presidentialists would say, the role of the president as commander-in-chief means there are a whole host of things. Rescue missions, airstrikes to respond to certain things, action against Syria for the use of chemical weapons, engagement against terror. They would say there are a whole host of other circumstances where the president can use force unilaterally by virtue of his being the president or being the commander-in-chief. So Congressionalists are going to say, no, pretty much every use of force, you need congressional authorization. Presidentials are going to say only in major sustained conflict. So you can see how these two schools manifest themselves in that concrete provision. Now, with those two schools, what trends have we seen in practice? We could put in many. I'm just going to give you three. One, we have seen the steady expansion of presidential authority since the Second World War. Second, we have seen some technological developments which have enhanced the president's authority in foreign affairs. And we have seen the continued reluctance of courts to adjudicate. So let me just talk briefly about those. So the expansion of presidential authority. And it didn't exactly start with Kennedy. You can go before Kennedy, but just to give you a sense, the reason I put Kennedy in there with Castro is because it was during the Kennedy administration and subsequent to that the United States tried to assassinate Fidel Castro. And I put Trump with Assad because it was recently disclosed that apparently President Trump was contemplating an assassination of Assad. So what have we seen? During the Cold War, Vietnam was authorized by Congress through the Gulf of Tonkin resolution, but there was a tremendous expansion of the war into places like Cambodia and elsewhere. It went beyond what many people thought Congress had authorized. And so we started to see this idea of presidential aggrandizement in foreign affairs. The same time, and I have Frank Church and John Tower over here. That gun that Frank Church is holding was supposedly a gun that contained a pellet, which if you were shot with it, would give you a heart attack. And it reflects the covert actions that really began during the Cold War period that were undertaken without any consultation with Congress, in the absence of any kind of intelligence committee. The Church Committee was really the beginning of the Senate Select Committee for Intelligence. And so there were coups or attempted coups against everybody from Mossadegh to Allende to Castro. As said numerous times, the United States tried to take Castro out, and Trujillo, a variety of other things that reflected this presidential expansion. And in that case, the use of covert actions under the authority of the president in the executive branch. Now, when the Cold War came to an end, they reined in some of those with the creation of things like the House and the Senate Select Committees. But you still had this idea of presidential war making without consulting Congress. So on the left, you see the invasion of Panama to get out Manuel Noriega that was undertaken by George Herbert Walker Bush. The right, you see Bill Clinton in 1999. Clinton was afraid that the Serbs were going to initiate ethnic cleansing against the ethnic Albanians in Kosovo. And so he began a bombing campaign in 1999 against Serbia without getting congressional authority. In the war on terror, so on the left, you see some prominent detainees. There was the whole detainee treatment issue and how the president was expanding his authority in treatment of detainees, which many said went beyond what was allowed under U.S. law. You saw the National Security Agency engage in the bulk metadata collection and a surveillance program, which many thought was expanded beyond what was authorized by Congress. And even in, we're not, I don't know that we're in the post-war on terror period, but we're going to call it that. You saw President Obama using military force in 2011 in Libya without congressional authority. And then recently, you've seen a couple of times where President Trump has engaged in airstrikes against Syria in response to the use of chemical weapons. So this continual expansion of presidential authority in this area, and the claim that the president had the authority to do it, and the actual practice of using military force abroad. Now, at the same time, to enhance, or has the effect of enhancing the president's authority, are certain technological developments. And the one I put there, it didn't start with either Clinton or Trump, but that's the so-called football. That, if you'll see it, there's a military aide in both of these pictures carrying what is a briefcase that, and I've never seen in that briefcase, so I don't know exactly what's in it, but it is widely accepted that it contains mechanisms for launching nuclear weapons, for accessing the nuclear launch codes. Well, I guarantee Madison and Hamilton didn't have any idea that the president would be able to do that. Back in their day, when you would start a war, you'd have to raise up troops. You'd have to build ships. It would be something that would take a long time. Yes, you could do it. You could fight a war, but it wouldn't happen at the snap of a finger. You couldn't obliterate the world with a snap of a finger. And so technology has played into the fact that now it is the president and the president alone that has the authority to enact a nuclear strike. Happens like that. Similarly, in the cyber realm, there are other ways in which the US and indeed other states can reach into the territorial integrity and political independence of states, whether it's something like the Stuxnet worm or other forms of cyber attack. And all these instruments, whether it's in the cyber command that's under the Department of Defense, being within the president's realm, it is the president who has the authority and can, in practice, authorize cyber action and cyber attacks. So all these technological, and there are other things we could mention, but I'll just mention those two, that have enhanced the president's authority in foreign affairs. Now, another trend I said is we've seen courts refusing to get engaged. And this is not by any stretch of the imagination the exhaustive list, but Mitchell versus Laird. So Congressman Mitchell brought suit against Melvin Laird, who was Secretary of Defense, about aspects of Vietnam being unconstitutional. It was thrown out by courts. We mentioned Goldwater versus Carter, thrown out by courts. Congressman Tom Campbell brought suit against Bill Clinton over Kosovo. It was thrown out. Now, Dennis Kucinich has got active a couple of times here. So in 2002, he brought suit against George W. Bush over the termination of the ABM treaty. It was thrown out and found to be non-justiciable. He then, a number of years later, brought suit against President Obama for the Libya campaign in 2011, and it was thrown out. There has been a consistent practice on the part of courts to stay out of deciding the merits of these cases where there's a conflict between Congress and the president in foreign affairs. Okay, so what's the answer? We've seen a constitution which is vague. We have seen a steady aggrandizement of presidential power, with presidents of both parties asserting more and more authority in foreign affairs. And we've seen them enabled by technology, whether it's nuclear technology or cyber technology. So what's the answer? How do we resolve this? Well, they're probably not good answers. We're not going to amend the Constitution. Every now and then, this is a completely different topic, but every now and then somebody will say, the Second Amendment, it should be written. It's not going to be. We're not going to amend the Constitution. We're not going to clarify in the Constitution the war powers. That's just not going to happen. Another thing that I think is a bad answer is what I'm calling constitutional line drawing exercises. Now, one example is the War Powers Resolution of 1973. So after Vietnam, Congress comes in and says, you know, we didn't like the way Vietnam turned out, and we're going to kind of blame it on the president. That's a little disingenuous, but that's kind of what happened. And so they said, okay, we're going to adopt the War Powers Resolution. It's going to restrict the president's authority to use military force. Well, President Nixon, not surprisingly, vetoed it. Congress overturned his veto by a 2/3 vote in both houses. It's basically meant nothing. The only thing that's actually happened is there have been some reporting that the president has done over the years, but the War Powers Resolution has not been an effective restraint. Why? Because it was Congress basically saying, we're going to draw this line. The president said, I don't agree with that line. Not only Nixon, but subsequent president says, I don't agree with that line. Without that consensus, without that agreement, that line drawing exercise is meaningless. Another bad answer. What I've called open-ended authorizations for the use of military force. So after 9/11, there was an AUMF. There was an authorization to use military force. Prior to the Iraq War, there was an AUMF. These authorizations reflected Congress allowing the president to use military force, a little bit like the Gulf of Tonkin resolution. They tended to be very open-ended. They had no sunset clauses in them. And the consequence is what's going on today in Iraq, Afghanistan, Syria, parts of North Africa has been linked to those resolutions, even though when they were written, they had nothing to do with the kinds of conflicts we're experiencing today. So open-ended authorizations, not a good idea. So maybe some ideas. What I call framework legislation. And I'd be happy in the questions to go into more detail here, but this is where you don't try to make a judgment on the ultimate constitutionality of something. War Powers Resolution did that. It said the constitutional authority, this is section 2C, the constitutional authority of the president to introduce troops into hostilities, blah, blah, blah. The Congress purported to say what the Constitution meant. And that was part of the bad line drawing. The Foreign Intelligence Surveillance Act of 1978 doesn't exactly do that. It basically says we are going to bracket the ultimate constitutional claims by the president with respect to surveillance of foreign powers or agents of foreign powers. We're going to bracket the ultimate constitutional questions. We're not going to say the Constitution says this, but what we're going to do is we're going to put together a framework which we hope is workable. We're going to get buy-in from the executive branch. We're going to get buy-in from Congress, and we're going to put together the FISA framework. Now, I know there have been some controversial things about FISA recently, and we can talk about it. But for the most part, that worked because it didn't make an ultimate constitutional red line. It put together a framework which both branches agreed to. Another idea is limited AUMFs. And this, I think, would be certainly the way many in Congress would want to go now. Certainly Senator Kaine would advocate this. You have a particular conflict, you authorize force for that conflict, you circumscribe it in a particular way, and you have a sunset clause. The sunset clause basically says this authorization is good for 6 months, it's good for a year, whatever. It can always be renewed, but it doesn't go on indefinitely, which is what the AUMFs do that we have today. By the way, a lot of UN peacekeeping resolutions have sunset clauses, either 6 months or a year. That was something that they learned the hard way as well. Final idea, and this is the hard one, return to bipartisan foreign policy. Right now, one of the biggest challenges we have is, and it's not just the current president, but you have presidents who assert their authority. And because of the hyperpartisanship, Congress, note, Congress is unable to assert its institutional interests. What Hamilton and Madison expected was this. If a president asserted too much authority, if a president got out ahead of himself or herself, Congress would say, that's a threat to our institutional interests, and we're going to act accordingly. Hamilton and Madison never thought that there would be parties the way they are, And they didn't think that they would be hyper partisan the way they are. And they didn't think that because of that, Congress wouldn't be able to exercise its institutional authority. So maybe if we're able to return to something resembling a bipartisan foreign policy, Congress will be more willing and able to exercise its institutional interest. So, the future? I'll leave you, before we get to questions, with the final quote from Jackson Brown. The future's there for anyone to change. How we move forward in the conduct of foreign policy and in the interpretation of the constitutional provisions on foreign policy depends on actions by people. It depends on what the next president will do, and it depends upon what the next Congresses will do. The future's there for anyone to change. Okay, Jim, let me turn it back over to you.
Excellent, Tony. Thank you so much for that really thoughtful and provocative exposition. So, folks, particularly those of you who are watching us on Facebook Live, if there's a question that you'd like to have asked, post it right into the comments. I'll pull it from there and be glad to read it aloud for everyone, and we'll go that way. I see some of you have already done that. I'm going to take the chair's prerogative and ask a couple of questions that rolled through my head. Tony, you know, the conversation about President Trump's stewardship of American foreign policy often gets wrapped up in this idea of an imperial presidency, that the president of the United States is the first actor in the constitutional order and is beyond restraint. What's your take on that? What did the founders really mean, and what did they intend when it comes down to that fundamental issue of that tension between who is the primary driver of foreign policy in the constitutional order?
So a couple things to note. It's a really good question. Is the constitutional framework that we have was our second government, and we always forget that. We first had the Articles of Confederation, and it failed. And it failed. It failed for a couple of reasons. One is there was no real central federal government. There was a Congress, but it couldn't mandate much. It had to ask the states for money. States were concluding treaties on their own, and it was just way too decentralized. So one of the things they were trying to do was centralize the federal government. There was no president. There was somebody presided over the Congress at the time, and John Hanson, I think, was the very first sort of president. He was the person who presided over the Congress. So there wasn't any. Now, when they went to a centralized system, what they were really afraid of was that Congress would be too powerful. And so they put a president in a presidential model, I think in part as a check on Congress. Now, they were concerned about the president, and if you read the Federalist Papers, they were concerned about corruption of the president and being corrupted in particular by foreign interests. That was something that was very specifically, there's several of the early Federalist Papers which talk about that. So they were concerned about that. They were concerned that there would be foreign interference. And they also assumed, though, that Congress would be able to provide an effective check. So they had a model of a failed central system where the Congress was not powerful enough. They wanted to make Congress more powerful, yet they wanted to make sure there was a president to manage certain things. They also had the referent of George III, where you really did have an imperial president. And I don't really think they were that worried about that. They were more worried that the Congress would have too much power. And part of it is the modern age, as I mentioned, with technology. And I think that was when we really started to see a change. They also sort of assumed, just to note this, that the U.S. would be more insular than it became after World War I. So if you look at Washington's farewell address and Jefferson's inaugural, they both talked about avoiding entangling alliances and not getting engaged in European politics. So coupled with the fact that they thought Congress would play a strong role, and with the fact that they assumed that the United States wouldn't want to engage in these wars abroad. I think the idea of an imperial presidency would have surprised Hamilton and Madison and Jay and all those folks. And again, they also would not have thought that, the challenge we have now is if Congress people, if the Senate and the House, or the Senate or the House, is nominated by people of the same party as the president, the party loyalty outweighs the institutional loyalty. They would not have envisioned that happening.
So, I am. We've got a couple of questions in. I'm going to ask one more, and then I promise we'll open up to others. You began your presentation with a reference to concern, and I think this is real, particularly among NATO watchers, that if President Trump wins re-election, he's going to withdraw the United States from NATO. You discussed how the courts have not wanted to engage on this issue. But I'm wondering if you can reconcile for me the faithfully execute clause of the Constitution, which says that the president will faithfully execute the laws of the United States. And if a treaty is the law of the United States, how can the president then abandon that treaty unilaterally?
And that's exactly one of the questions that the district and the circuit court took up in Goldwater versus Carter, with them going a couple of different ways on it. Now, and it gets a little technical, which I'll do in a second, but to the broad brush would be, some of the courts and some of the advocates said exactly that. A treaty under the Constitution is part of the supreme law of the land. The president cannot unmake the law. The president can't just unilaterally terminate a statute. Therefore, the president shouldn't be able to unilaterally terminate a treaty. And so that was an argument that was made, and that was one of the circuit court had a bunch of arguments, but that was one of the persuasive arguments in the circuit court. Now, the contrast is that the president makes treaties in a way different from legislation is made. So legislation requires both houses of Congress, and it then goes to the president. The president can veto it. If it's vetoed and it's overridden, it becomes the law. So there's a fully different process. If you look at Article 2 of the Constitution, which I had up there, it says the president makes treaties with the advice and consent of the Senate. So the idea is that's the process to make them. But because the president, the argument goes, is the primary mover in making, why shouldn't the president be the primary mover in unmaking? And I mean, it's a good, I mean, it's an argument. I mean, and that was enough for some people to say, like, okay, well, then the president should be able to do that. So, and ideally, the courts would get involved and would reconcile it. And it gets a little more complicated. I said it gets a little bit in the weeds. The Taiwan Defense Treaty had a termination clause. Now, the termination clause didn't say the president can terminate. It said the United States or Taiwan would have the authority to terminate. But the court read it as, or one of the courts read it as, because it was there and Congress didn't clarify, or the Senate didn't clarify it, that can also be seen as empowering the president to terminate. Now, again, you could read that one way or the other, too.
So I'm left to be unsatisfied.
Rightfully so. Rightfully so.
Yeah. Well, look, we've got a few questions that I want to get to from the audience here. Michael asks, haven't GOP members of Congress been Congressionalists when a Democrat was the president? And we could make that a bipartisan question. Haven't main party members essentially resisted the prerogative of the president when the president wasn't of their party? Is this just the Potomac two-step?
So I would argue a couple of things there. I would say of late the answer is yes, because there are things which, say, a GOP president does that if a Democrat did, the GOP in Congress would scream bloody murder, and vice versa. So of late, what I would say, and that's one of the reasons why I put Goldwater in there, is Goldwater had a tradition, even though he was against Carter in that particular case, had a tradition of asserting congressional authority. And that's one reason why I raised the question about Biden, too, is I'm not sure if Biden were elected or is elected, he will assert presidential authority and be encouraged to do something, to do so. But I bet you his, however long it was, 50 years in Congress, 40 years in Congress, will have had an impact on him. And I would not be surprised if he's a little more of a congressionalist than most of his predecessors. So I think in response to the question, today, yes. Today it seems all about party affiliation. But I'm not sure traditionally it was as much that case. Let's go back to when the UN Charter was adopted, since we got to bring up Claiborne Pell again. So one of the things that Truman did, which Wilson did not do with the League of Nations, was he made sure to reach out to the Republicans and get them engaged. And John Foster Dulles was one of the people who was at the UN conference, but also playing a very critical role was Senator Arthur Vandenberg and Senator Tom Connally. So Connally was a Democrat and Vandenberg was a Republican. And both at various points in time had been chair of the Senate Foreign Relations Committee. And I think one of the reasons he brought them in is because they reflected the interest of Congress, and he understood that Congress is going to have its interest irrespective of party affiliation. So I think there was more of a nonpartisan approach to being a congressionalist or a presidentialist, in the 40s and the 50s than there is today. And as I said, there are some in Congress still who are just traditionally presidentialists and some who are traditionally congressionalists. But I think on a whole, we've seen that go away as we've seen much more of a partisan divide.
Okay, so Larry says that after a 30-year diplomat career, now retired, and as a former attorney, I think your discussion largely ignored having a president who ignores the restrictions of the Constitution, for example, the emolument clause. Given that conduct, it is difficult to foresee how any restraints are practical in any short-term situation. Isn't this discussion largely academic?
Well, so the president that's currently challenging the efficacy of the emoluments clause is the current president. And however things turn out in a couple of months, the current president will not be the current president forever. And so I think these are a little more than just academic discussions. I mean, I would be less than honest if I didn't say that the assertions of presidential authority we've seen in this administration are unprecedented. I just think that to be pretty clear. And I would say, as such, this administration is a bit of an outlier. Now, two things to note. One, there has been a steady aggrandizement, assertion of presidential authority in foreign affairs, since World War II. Steady. I mean, I don't really think there were any presidents that didn't do so. There's been that steady increase. At the same time, there has been a steady reluctance on the part of Congress to effectively challenge any president in those areas. So that's kind of been the trend line. And then the current president kind of throws everything up in the air, and there's all sorts of challenges. And it has been an unprecedented assertion of presidential authority and expression of presidential attitudes with respect to the rule of law, unlike anything I've seen. But again, the current president won't be president forever. At some point, there's going to be a new order, and some of the ways in which we have to address these issues, some of the things I suggest and others suggest, are going to become more palatable and more important in subsequent administration. So I get exactly, I guess, Larry's point. I get exactly what he's saying, but we have to sort of think beyond the immediate.
Question from Michael. How could we create an efficient bipartisan foreign policy making process between the president and Congress, resolving disagreements so that decisions can be made timely, whether developing long-term strategies or reacting to overseas aggressive acts?
Yeah, so I wish that is the question. I wish I could give you a magic bullet on that question. It's a question I get from students a lot of times. They say, this period of hyperpartisanship, when are we going to get out of it? The truth is, I don't think there's an institutional solution to that. I think it really depends upon the people that end up occupying these offices. Now, we've had periods in this country of great divide. And the Civil War was a tremendous period of great divide. When Joe McCarthy was out and about doing his thing, there was a tremendous divide. And so we go through cycles. I think ultimately the only way we're going to get out of this cycle is for cooler minds to prevail, for people to be elected who are going to have a different sort of attitude, who are going to resolve themselves and do this. At some level, that's up to the American people. That's up to the culture we're in. We can put in whatever institutions we want, but unless we have the right people occupying those institutions, they're not going to be very meaningful. Now, this is something that I should note. A lot of times people say, "Oh, American institutions are strong; they can deal with everything." Well, there's no such thing as an entity called an institution that is separate from human beings. And any institution is occupied by people. And so whether it's Congress, whether it's the president or the courts, the institutions are only as strong as those individuals. And so the only way to get out of this hyper-partisanship and to return to a more bipartisan foreign policy is to bring in people. Now, I will say this. In the past several years, the courts have played a very important role. They haven't done anything in foreign policy because of their tendency to say these are non-justiciable issues. But in a lot of other issues, the courts have been a bulwark of maintaining order and stability. And I think we continue to see that. And we see judges that have been appointed by presidents of all parties playing that role. I remember how irritated Chief Justice Roberts was when people were being referred to as an Obama judge or a Trump judge. And he says, there's no such thing as an Obama judge and Trump judge. They're U.S. judges. And I think, obviously, there are outliers in the courts, too, but I think on a whole, they've played that institutional role. But for the elected institutions, Congress, the president, it ultimately depends upon the people that are in them that will then allow those institutions to play their institutional role.
You actually, I think, anticipated in some respects Dimitri's question, which is, he's expressing concern for the abject failure of the Congress to hold the president accountable. But he asks specifically whether or not this is the result of polarization in the American body politic, and in particular, the result of gerrymandering of congressional districts.
So, yeah, I think yes. So I think there's several factors. The gerrymandering of congressional districts is one. I don't blame social media. I don't blame cable TV, et cetera, but they tend to amplify the extremes. And they tend to encourage people to go to the extremes to get recognized. So they tend to play that role as well. There's another thing, and that is the election cycle and the amount of money required to run for office, whether it's for Congress or for the president. People that get money are also people that tend to be at the extremes. And people are now campaigning. You get elected to Congress, what's the first thing you do is start campaigning for your next election. And you've got to go back to your districts. Now, transportation and technology means everybody goes back to their districts every weekend. Now, what does that mean? That means you don't sit in Washington, D.C. I know it's not always a pleasant place to sit, but you don't sit in Washington, D.C. and shoot the breeze with your fellow members of Congress from each party. I feel like in the 50s and the 60s, when people mostly stayed in town when Congress was in session, they got to know one another. They got to be friends with one another. The old example, Tip O'Neill and Ronald Reagan sitting down together. And as a consequence, they didn't see each other as caricatures, as extremes, but as people and as friends. I mean, I think of the relationship between Ruth Bader Ginsburg and Antonin Scalia. They were friends. They obviously had differences of philosophy and legal interpretation, but they were friends. You used to see that happening in Congress when people were here. But the combination of being able to get to your districts and the election cycle and the amount of money means, in my view, that Congress people don't have a chance to build that esprit de corps and get to know each other as much as possible. Again, I don't want to put everything there. I think gerrymandering is important as a contributing factor. I think media, cable news, social media, and things that tend to push things to the extreme also contribute to that as well. But I do think not being able to sit in the same room and get to know one another and realize that we're all in it together. Let me throw in another factor on partisanship. So when I was an intern on Capitol Hill, I interned for Senator Mathias from Maryland. Senator Mathias was a Navy veteran. Just about everybody in Congress in those days was a veteran. Now, what does that mean? That means they'd all fought a war together, and most of them in those days had fought World War II together. They understood that country was more important than party. They really did understand that. And I think that was something that brought them together in a way, that kind of bonding experience that we don't see today as much with members of Congress.
We've got we're at the 1 hour mark, and so we want to be respectful of everybody's time. I've got one more question I want to get. It's from as experienced a DC hand as I know, Tom Hughes, who's actually Senator Pell's former chief of staff. And he asks about the potential for Congress to use the power of the purse, its appropriations power, to constrain the executive, provided, of course, that both bodies can override a veto. Is that likely? Is it possible?
Yeah, so it depends on what the it is. And I mean, yes. So that's actually how Vietnam ultimately came to an end, is Congress said, we're not going to we're not going to allocate money to Cambodia. We're not going to, so that could play a very critical role. And the problem is, so you can't use that, like if the president pulled out of NATO, I mean, you can't really use the power of the purse once he's kind of done that. You also have difficulty in the immediate actions. So the president has the military. The president can use force in Syria right now. The money's been appropriated. The president, sadly, could launch nuclear weapons against North Korea. There was something that recently came out that he was apparently contemplating that, because all that money's been appropriated. The power of the purse is going to be effective in things like Vietnam or the Iraq War or the Afghan War, where there's an ongoing conflict and Congress can say no more, we're going to stop it. So yes, the power of the purse can be very, very effective there. But where you have, trillions of dollars that are allocated to the defense industry that have created technology, the power of the purse is not going to be able to stop something that's quick, that's immediate. And it's also not going to be able to stop things like pulling out of treaties and some other things, unfortunately.
Well, that is unfortunately where we're going to leave it. I want to thank the Pell Honors Program again for its joint sponsorship of tonight's event. Tony Arend, I want to thank you for just a great conversation and a great presentation. And I want to thank everybody in the audience who joined us tonight. This video, if you're interested, will be live on Facebook in perpetuity, so you can come back and watch it and revisit it. One of the downsides of tonight is that we don't get to all give you a big round of applause, Tony, but you get my golf clap, and I thank you very much for being with us. Thank you all very much, folks. We'll see you again in the coming weeks.